You decide what happened, what is the truth of the situation, and what are the facts. Then you apply to those facts the law that I give you, and just as you are supreme in deciding questions of fact, I, as the judge, am supreme on questions of law, and whether or not you like the law that I give you, you must accept it. This is our system of jurisprudence. You determine the facts, and then you apply those facts as you find them to exist, the law that I give you, and render a verdict accordingly. In determining the facts, you should not leave behind you your everyday common sense. There, you are called upon to determine the credibility of witnesses who have taken the stand. This happens to you in your ordinary walks of life. You meet people in your ordinary walks of life, and you have to determine from time to time, are they telling the truth? Are they exaggerating? What is the probability of the story that they are telling? Is it true? You measure the probabilities by the manner in which they tell it. The answer is in which they talk. The interest, if any, they might have in exaggerating the story or in telling it in a particular light or color. All of those summations or situations you meet in your ordinary walks of life, and it is just in that way that you determine whether or not a witness is telling the truth. There has been some reference in both summations here to the failure to call witnesses. The failure to call any given witness does not constitute evidence. It is not proof of any fact, nor is a party under a duty to call any given witness. Where it is apparently within the power of a party to proceed to produce a witness whose testimony it appears would throw additional light upon the controversy, the unexplained omission of that party to produce such witness authorized you, as the jury, if under all the circumstances of the case you consider such a course justified, to give favorable consideration to the testimony or contention on behalf of the opposite party, which the testimony of such witness, if produced, might have contradicted or explained. Of course, if you find that any witness in the case has willfully testified falsely as to any particular matter, you are at liberty to disregard the entire testimony of that witness. This is on the theory that if a person will testify under oath falsely as to one matter, he or she is likely to testify falsely as to all matters. On the other hand, you do not have to disregard the entire testimony. You can take that part which you believe and throw out the incredible or false part. You are seeking the truth. You are getting down to a determination of the truth, and these are the basic rules of law in connection with that objective. You might say, well, there are 5 people who testified to one thing and only 1 to another. However, as I just told you, you are seeking the truth of the situation, and you do not make a decision on a question solely on the number of witnesses who testified one way or the other. It is the quality of their testimony that counts rather than the quantity of it. It is what you believe. You are seeking at all times the truth of the situation. What are the issues of this case that you have to decide? We have set forth in this complaint 4 separate courses of action. In the first cause of action, the plaintiff, William Hans, seeks damages in the sum of $10,000 for personal injuries, which he says he received in this accident. In the second cause of action, the plaintiff, Emma Bell, seeks the sum of $50,000, not $25,000, as counsel said in his summation, but according to the complaint which has been given to me, $50,000 for personal injuries, which she claims that she has received in this accident. In the third cause of action, her husband, Herbert Ball, sues for the sum of $10,000 for medical expenses and loss of services of his wife. In the fourth cause of action, the plaintiff, Stanley Peters, sues for the sum of $5,000, claiming that he was injured in this particular accident. Each one of the plaintiff's actions is based on what we call negligence. The mere happening of an accident with a subsequent injury and damage does not mean that someone is responsible and that someone must pay damages. A recovery by any one of these plaintiffs cannot be had under any circumstances without a finding by you that the defendant has failed to perform some duty which it owed to this particular plaintiff, and that his failure was the correct and proximate cause of the damage and injury which they sustained. Each plaintiff must prove negligence on the part of the defendant, negligence which was the proximate cause of this accident. Each plaintiff must prove freedom from any negligence on his or her part which contributed even in the slightest degree to the cause of the accident, and each one must prove his or her injury. The burden of proof is upon such plaintiff to prove their case by a fair preponderance of the evidence, if you please.